So I want to talk with you for a few minutes today about the Family and Medical Leave Act. Along with the Americans with Disabilities Act, the FMLA continues to pose many challenges for employers. As a management side employment law attorney, clients often have questions about technical requirements of compliance and also many of the issues that are ill-defined by the FMLA statute and regulations. So briefly, the FMLA applies to employers who have 50 or more employees in a 75-mile radius and to employees who have worked for the employer for 1,250 hours during the 12 months prior to leave. The FMLA provides 12 weeks of unpaid leave for a qualifying serious health condition. So questions come up as to whether the employer can reach out to an employee while they are on leave. And the answer is it depends. The good news is that you do not have to leave the employee completely alone. The FMLA allows employers to ask an employee on leave for periodic updates on their leave status or intention to return to work and other administrative things. You can ask the employee on leave for work-related information such as the location of work files, the status of pending work projects, and other things that relate to general business. The occasional telephone call or email like this for administrative updates do not interfere with the employee's FMLA rights. The not so quite good news, however, is that the FMLA does not allow you to reach out to the employee to demand substantive work from the employee on leave, such as a request that an employee on leave complete or continue work on work product while they are on leave. The more substantive the work is that you ask an employee to do while they're on leave, the more likely it is that the employee could claim that you interfered with their FMLA leave rights. You cannot coerce or pressure an employee into performing substantive work while they're on FMLA leave. Don't do it. However, if the employee on leave voluntarily and without any coercion from you wishes to work while they're on leave, the FMLA permits it. The key is that the employee's desire has to be voluntary. Working while on leave cannot be made a condition of continued employment, as one court put it recently. The key here is the voluntary nature of the employee's willingness to perform the work. Be measured in your communications with the employee on leave not to inadvertently create any perceived pressure on the employee to perform work. Be sure to document the employee's voluntary desire to perform work while on leave, and be sure to account for the fact that the employee's work time while they're on leave is compensable. Be sure to adjust the employee's FMLA leave balance for any time the employee spends working. And these last two items can be difficult for an employer to do, so be careful with it and make sure that you're accurate. And that's all for today on the Family and Medical Leave Act.